The U.S. Securities and Exchange Commission's motion to strike Ripple's lack of due process and fair notice defense should be denied, according to a new legal filing by Ripple. The SEC's motion to strike Ripple's affirmative defense fails to meet the demanding legal standard required, argued the defense attorneys representing Ripple, a San Francisco-based payments technology company. An affirmative defense is one in which the defendant introduces evidence that, if proven, mitigates the defendant's legal liability. At the heart of the SEC v. Ripple lawsuit is the status of the XRP token and whether transactions involving XRP constitute investment contracts and therefore securities subject to registration under Section 5 of the Securities Act of 1933. The SEC had sought to dismiss one of Ripple's core arguments that the SEC failed to provide fair notice that XRP transactions violated the law or that the SEC would later claim XRP itself to be an investment contract. Instead of challenging Ripple's defense as a matter of pleading, the SEC instead seeks a premature judicial determination of the ultimate merits of Ripple's defense, asking the court to credit disputed facts set forth in the supplemental declaration of the SEC's trial attorney, asserted Ripple's attorneys in a 34-page memorandum of law filed on May 13. This is improper. The court cannot, as a matter of law, rely on disputed facts proffered by a plaintiff to foreclose a legally cognizable defense. Ripple's attorneys are also seeking to bolster their fair notice defense. Ripple's fair notice defense comes directly from controlling Second Circuit precedent, Ripple's attorneys wrote, citing the Upton v. SEC case where the Federal Appeals Court held that the SEC could not apply enforcement action when the defendant did not receive reasonable notice that its conduct was unlawful. Ripple contends that XRP is a virtual currency and not a security. Transactions in XRP are recorded on the XRP ledger, which is decentralized software code that originated in 2011 to 2012, before Ripple was founded. The attorneys wrote, Ripple has never explicitly or implicitly promised profits to any XRP holder, and has no relationship at all, contractual or otherwise, with the vast majority of XRP holders today, nearly all of whom purchased XRP from third parties on the open market, the attorneys continued. What limited contracts Ripple did enter into with sophisticated institutional counterparties were not investment contracts, but standard purchase and sale agreements with no promise of efforts by Ripple or future profits. Ripple alleges that a wide variety of people of ordinary intelligence, ranging from individual purchasers of XRP to sophisticated exchanges and broker-dealers, to the SEC's own commissioners and senior officers, did not know that XRP was an investment contract and therefore a security, as shown by the statements and conduct of those various actors, the attorneys added. Had the law provided sufficient notice, then market makers and exchanges that executed transactions in XRP, not to mention the numerous individuals who purchased and used XRP, would have organized their affairs so as to comply with the requirements of the federal securities laws and regulations. Ripple further asserted that its settlement with the U.S. Treasury's Financial Crimes Enforcement Network, FinCEN, and the Department of Justice in 2015, as well as the SEC's guidance, did not provide fair notice. SEC issued reports, such as the report on the DAO and enforcement actions from 2017 onward, concerned initial coin offerings ICOs, which Ripple did not hold, the defense attorneys argued. There is a genuine dispute as to whether a person of ordinary intelligence would have concluded that the SEC's actions suggested that XRP was, or was not, a security, given the SEC's focus on ICOs.